In this video and in the next one, we're going to be considering the terms of a contract and the contents of the contractual agreement. What we're going to be looking at is first of all the express terms and how does a pre-contractual statement by one party become an express term of the contract. We'll look at all of the rules that govern that, such as the timing of that pre-contractual statement, its importance, who said it, what was their specialist knowledge or skill, and all of the rules that surround incorporating terms into an agreement as well. We will then also look at implied terms and the various different provisions that will be implied into a contractual agreement by the likes of the Sale of Goods and Services Act and the Sale of Goods Act as well. And then lastly, we're also going to look at the nature of terms. Are they conditions, are they warranties, or are they anonymous terms? And then we'll look at what the repercussions of breaching those terms is and how it differs depending on the characterization. In this video, we consider express terms of the contract. Apart from looking at the definition of what amounts to an express term, we're going to break it down by looking at three different things. The first of which is pre-contractual statements. And when do statements made pre-contract actually become express terms of the contract? And what happens if they don't? What happens if those statements are mere representations or mere puff? We will then move on to look at the related rule of the parole evidence rule, which dictates that extrinsic evidence cannot be used to change or alter or to contradict the terms of a written contract. But there are exceptions to that, and we will also look at those. And then finally, we will look at the special rules which govern onerous terms, and did the party which seeks to rely upon them take reasonable steps to bring it to the attention of the other. Starting then, as we always do, with our context, we have now moved away from contract formation and we are now in contract at this point. So we're considering the contents of a contract. In this specific video, we're looking at express terms only, but in the next one, we will move on to consider implied terms, and then we will further move on to categorize terms into conditions, warranties, and anonymous terms. But we're in contract at this point, and that is the key takeaway from this slide. Starting then with a very straightforward definition of what amounts to an express term, it is simply a statement made by the parties by which they intend to be bound. That statement can be made orally or it can be made in writing, or there can be some sort of mixture of both, and that is perfectly fine to have, and that's what we have on the third bullet point there. We have an example that the parties shall act in a spirit of mutual trust and cooperation. That's an express term of the NEC 3 form of contract at clause 10.1 or part of that clause, and that's something I'd be very used to seeing as a construction lawyer. But we've just got it there as an example of an express term, something that the parties have agreed up front expressly to be bound by. The key skill when it comes to express terms, and what most examiners will seek to test you on, is being able to identify the difference between an express term and a mere representation, something that induced the contract but is not a binding part of it. And that's what we're going to look at throughout the remainder of this video. The various factors which the courts will take into account in deciding whether a pre-contractual statement is either a term of the contract, an express term, or a representation. Our final piece of perspective then, we're going to start, as we say, by considering pre-contractual statements and how to categorise them into mere puffs, seals, pitch, for want of a better word, into representations, things which induce the contract but are not part of it, and then finally terms of the contract, which are the binding obligations on the parties. Then we'll move on to consider the parole evidence rule, which, as we said at the beginning, is that rule that extrinsic evidence outside of the contract cannot be used to inform the contents of it or to contradict or to vary the terms of the contract. But there are a couple of exceptions to that whenever there's an intention for the written contract not to be the entire agreement between the parties. And then finally, we'll look at the rule in interphoto and stiletto when it comes to onerous terms and the added onus on the party seeking to rely upon them to bring them to the attention of the other party and to take reasonable steps in doing so. It's not about actual notice, it's about taking reasonable steps, and that is the key. Looking then at pre-contractual statements. So what I would always advise people to do who are approaching this topic for the first time is to think of two parties, hypothetically, who are about to enter into contract. Those parties will always make some sort of pre-contractual statements towards one another, or most of the time they will. And the role of the lawyer is to analyse those pre-contractual statements and to categorise them into one of the three things that you see on screen. The statements will fall into one of these categories. They cannot straddle both. So those categories are mere puffs, representations, and express terms of the contract. The first category, mere puffs, that simply relates to salesmanship, or something or a statement that was made that has got no legal significance. For example, you walk into a car dealership and the car salesman sets out that the car is the best thing that he has ever received into the showroom, or it's the best car in the world, the most luxurious car in the world. Those statements are examples of puffery, sales puffery. Those statements have got no legal significance, partly due to the entirely subjective nature of them. They do not give rise to breach of contract because they're not contract terms, and they do not give rise to actionable misrepresentations because they are not representations. And we will look at that in more detail shortly. The other two categories are much closer together and they can be much more difficult to draw the distinction between them. And that is representations and terms of the contract. So a representation is a statement of fact or law which is used to help induce the contract, but it is not actually held to be a term of the contract itself. And that could be for a variety of reasons, which we will look at shortly. And then the other and the final category is a term of the contract itself, or an express term. And that is a statement of fact by one or both of the parties that they intend to be binding. And it's all about that intention for it to be binding. In terms of why it is important to categorize a pre-contractual statement in this way, we will look at in the next slide, but it's all about the repercussions and the remedy available to the innocent party for that statement turning out to be incorrect. So now that we all appreciate that pre-contractual statements can be categorized into one of the three things you see on screen, we're now about to analyze what happens if those pre-contractual statements turn out to be incorrect or turn out to be false. So if a pre-contractual statement which amounts to a mere puff turns out to be incorrect, then unfortunately the innocent party has got no remedy available, and for good reason. Because the mere puff was clearly not intended to be part of the contract and it clearly didn't induce the contract. So why should there be a remedy available for that? Using our previous example, if the car salesman sets out that in his opinion the car is the best thing he has ever seen in the car showroom, why should you be able to sue him if that turns out to be incorrect? Because after all, it was simply his opinion. It was you that should not have relied upon that because it was clearly just salesmanship. The other categories then are representations and terms of the contract. And if they turn out to be false or they turn out to be breached, then the innocent party does have a remedy. But the key thing to remember, and this is why we break it down in this way, is that the remedy is different. There is a different remedy available when a representation turns out to be false compared to when a term of the contract is breached. And one of them is much more serious than the other, and therefore one of them gives rise to a much more favourable remedy to the innocent party. And that is obviously breaching a term of the contract. So if a representation turns out to be false, that is what's known as a misrepresentation, a misrep, and we will cover that in much more detail in a later video in this series. But for now, you just have to appreciate that there are three different types of misrepresentation. There is fraudulent misrep, which is the worst kind, there is negligent misrep, and then there is innocent misrep. And they do exist on that little sliding scale, with fraudulent giving the most favourable remedy to the innocent party, to innocent, which gives very little remedy to the innocent party. The key thing to remember when it comes to misrepresentation and with respect to the remedy available is that the damages that you get for misrepresentation are designed to cover the losses that the innocent party suffered. They are designed to restore you up to the position that you would have been in had the misrepresentation not occurred. That is broadly equivalent to what you can recover in a negligence claim or in tort, but that's something we'll park for now. That can be dramatically contrasted to what the innocent party can recover when it comes to breach of a contract term. So generally speaking, the aim of damages when it comes to breach of contract is to put the innocent party into the position they would have been had the contract been properly performed. And that is generally what people go after, and that is generally what we refer to as the expectation interest. So what did the innocent party expect to make out of the transaction or out of the contract? So to illustrate using my hands, misrep is designed to cover the losses suffered by the innocent party, but damages for breach of contract are designed to cover the innocent party for what they would have made had the contract been properly performed. So if they were going to make 100 grand out of that contract, it's designed to restore them to that position where they would have 100 grand in their bank account. But misrep, on the other hand, if you've spent 100 grand because of that misrepresentation, it is merely designed to get that 100 grand back to you. It does not look forward to what you could have made had the contract been fully and finally performed. So what we are now about to consider is the different factors that a court would take into account when determining whether or not a statement made pre-contract is a term, so a binding part of the contract, or a representation, something that is not a binding part of the contract. The ultimate aim of the court, and always to remind ourselves when we're looking at these 5 factors, is to determine what the objective intention of the parties was. So the 5 factors that we're about to consider are just used by the court to answer this first question. What would the reasonable man or woman understand to be the intention of the parties, having regard to all of the circumstances? So what would that reasonable hypothetical person think the parties intended by that statement? Did they intend it to be a term, or did they intend it to merely be a representation? So the 5 factors that we're about to go through in detail are simply geared towards answering that question. The 5 factors are in no particular order, and not one of them is more important than the other. The courts will take them all into account in a 5-way balancing act in helping them to arrive at the answer to that question that you can see on screen. The first of our 5 factors then is whether or not the contract was reduced to writing. So the parties were having all of these pre-contractual statements, and then just before they entered into contract, they reduced their agreement into writing. So that's what we're discussing here. And I think for obvious reasons, the presumption and the general rule is quite clear that comes out of this. And that is that statements within a written contract are terms and they are not representations. And moreover, that reducing a contract to writing displaces any other pre-contractual statements that are not contained within the written agreement. So that is what that general rule is all about. And we have an extract from the leading case on that, which is Entrepreneur Pub and East Crown back in 2000, where the court set out that it is a prima facie assumption that the written contract between the parties includes all of the terms that the parties intended to be binding between them. In terms of the facts of Entrepreneur Pub and East Crown, it also goes to illustrate this point quite well. So the parties in that particular case entered into a rental agreement on the basis and on the promise that the person who was renting the pub would continue to purchase the beer off a certain supplier. All of that was made orally. Then when it came to actually drawing up the agreement between the parties, they reduced it to writing. So by reducing that agreement into writing, that promise that they would get the beer from the set supplier was ultimately ousted, and it did not form part of the written agreement. So whenever one of the parties ended up purchasing beer off another supplier, they were not in breach of contract, because that promise to get the beer off the original supplier did not actually form part of the final contract, because it was displaced by the general rule because they reduced the agreement to writing. So in that particular case, you can distinguish it between the latter case of J. Evans and Son and Andrea Mazzario. In that particular case, there was a clear intention between the two parties to have a mixed contract, both partly written and partly oral. There was a clear intention to have part of the contract on written shipping terms, which is what our diagram is all about, and we will cover the facts of that case in more detail shortly. And there was also an intention to have an oral element of the contract on that mixed basis. So whilst the general rule is that a written contract contains all of the terms, if you can prove that the intention of the parties was to have a mixed contract, then that general rule will be displaced. Factor number 2 then is the importance of the pre-contractual statement. And I think this one is also quite obvious when you think about it theoretically. So the general rule is the more important the pre-contractual statement is, the more likely it is to become a binding term of the contract as opposed to a mere representation. So the way you might want to think about that is, would the parties have entered into the contract but for that statement being made? If the answer to that is yes, and the parties would have entered into the contract anyway, then the statement is probably not that important. But if they would never have entered into the contract but for that statement being made, then that goes towards showing that it is very important and that this factor would be coming into play. In terms of the facts then, and the leading case of this is Bannerman and White. That third bullet point is what we're talking about there. Do these hops contain sulfur? So in Bannerman and White, Bannerman set out expressly that he needed hops and he was going to use them for making beer. And he expressly said, if these hops contain sulfur, I do not want them because it's important for me that I use the hops for making beer and they cannot have sulfur. Ultimately, White turned around and said, no sulfur in these hops, they'll be grand for making beer, and the parties entered into a contract. You can probably imagine what happened here. The hops later turned out to be treated with sulfur, and Bannerman sued White for breach of contract on the basis that White's promise about the hops being free from sulfur was a term of the contract. And the courts had no problem in agreeing with Bannerman there. They held, you set out, Mr. Bannerman, that you did not want hops with sulfur, and he clearly knew that that was important to you when he made the statement that the hops were free from sulfur. So because of the importance of that statement being made from White to Bannerman, the courts held that that statement was a binding term of the contract. And when the hops later turned out to be fully sulfurous, that was a breach of contract and Bannerman was successful. Our third factor then is all about the specialist knowledge or skill of the person making the statement. So the general rule here is, if the person making the statement has got specialist knowledge or skill about the content of that statement, then that statement is more likely to be a term of the contract as opposed to a representation. So if I am really knowledgeable about the statement that I am making, it is more likely that my statement will be a term as opposed to a representation. We've got two very useful cases to illustrate this point. Again, they're both very similar on their facts with two entirely different outcomes. So the first of which is Dick Bentley and Harold Smith Motors. So this is all about the car dealer being Mr. Harold Smith making a statement to the customer. So it's the dark blue arrow on our little diagram there. So the car dealer here is Mr. Harold Smith, an expert in selling cars, and he is making it to Dick Bentley, the lay customer. So in that particular case, the car dealer set out that the car had done 20,000 miles and the customer purchased it on that basis. It later transpired that the car had done many more miles than that. We'll not get into the detail about how the odometer managed to be changed, but ultimately that was a breach of contract because the expert car salesman should have known that the car did more miles, and that statement was a term of the contract which was breached, and Harold Smith was liable for breach of contract there. That particular case can be contrasted with the other case of Oscar Chess and Williams of 1956. So it's the opposite way around here, and it was a lay customer making a statement to an expert car dealer. Again, the exact opposite in terms of its facts. So the lay customer, who was the son of an individual who purchased this 1948 model car, made a statement that the car was a 1948 model. He made that statement because that's what the logbook that came with the car actually said. It turns out that that logbook was the incorrect logbook for the vehicle. But the lay customer and the son was not to know that. Anybody who does not have expert knowledge about cars would only ever look at the logbook. And the court held in that case, when it transpired that the car was actually a 1939 model, that was a mere representation. It would have been up to the car dealer to check the validity of that prior to entering into the contract, if he wanted to rely upon that as a contract term. So the statement made in that case was a mere representation. It was not a binding term of the contract to which the customer could be held liable. Factor number 4 then is the timing of the pre-contractual statement. So the general rule here is if the pre-contractual statement is made just before the contract is entered into, then it is more likely to be a term of the contract as opposed to a representation. But on the other hand, if there is a delay between the statement being made and the contract being entered into, then that's more likely to be a representation, because that lapse of time is likely to point towards it merely being a representation as opposed to an express term. The case that we have for that is the Court of Appeal decision in Rutledge and McKay, all to do with the sale of one of these Douglas motorcycles with a sidecar. So in this particular case, the parties agreed orally that the bike was a 1942 model and they agreed to sell it for 30 quid. So they made all that agreement orally. But a week later, the parties then entered into a written agreement. So they decided to reduce that contract to writing. So as we talked about previously, the initial assumption there is that the parties have reduced all of the terms into that contract. But the courts will also take into account the wider contractual matrix to see if there was actually an intention to have a mixed contract of both oral terms and written terms. But in this particular case, because a week went between the statement being made and the contract actually being reduced to writing, the court held that the statement was a mere representation. If it was made a couple of minutes before the parties signed the dotted line, that might have been a different story. That might have evidenced an intention to have a partly written, partly oral contract. But because the oral statement was made 7 days prior to that, the court held that to be a mere representation and not a term of the contract. Our final factor then is when the statement maker accepts responsibility for their statement. So the general rule here is when a party makes a statement and they accept responsibility for it being correct, then it is more likely that that statement will be a term of the contract as opposed to a mere representation. And I think the reason for that is quite obvious. But it is well illustrated on the facts of the leading case of Schwall and Reed on this point. So in this particular case, Mr. Schwall was purchasing a horse off of Mr. Reed, and he went to view the horse just before the contract was concluded. And in doing so, Mr. Schwall set out that the horse was going to be used for studding purposes, so for procreating other little horses. And Mr. Reed, in response to that, set out that this horse is sound, it can be used for that purpose, I accept responsibility for that, and you don't need to have your vet check him out to make sure that he is fit for studding. It later transpired that the horse was a bit useless, it was not fit for studding, it was a limp horse, and ultimately the court had no problem in holding Mr. Reed's statement to be a term of the contract, and Mr. Schwall was entitled to damages and to repudiate the contract, return the horse and get his money back. Moving on then to discuss the parole evidence rule. So this is a separate, albeit related topic to what we've been discussing thus far, and that being pre-contractual statements. And again, I'll explain the linkage between what we've discussed up until now and the parole evidence rule shortly. So the parole evidence rule is a rule of contractual construction. So it's something the courts will take into account when constructing contracts or interpreting contracts. and it effectively dictates that the courts, when they're dealing with a written contract, will not look at any extrinsic evidence, any prior agreements or any other information for that matter to inform the contents of that written agreement. That is the presumption anyway. It is up to the parties to displace it, and they can do that. If the parties can prove that there was never an intention for the written contract to contain all of the terms, so if there was an intention for the contract to be a mixed oral and written contract, then this parole evidence rule does not count. But the presumption is that if the contract is reduced to writing, then it will include all of the terms. And we looked at the case of Entrepreneur and East Crown previously for that particular legal point. When it comes to commercial contracts, parties to those agreements will usually include a boilerplate piece of drafting, which is an entire agreement clause. And that will effectively set out that the parties to this agreement agree that this is the entire agreement between them. And that will effectively displace any other previous agreements or any other discussions or negotiations that were had. Anything that is not bound into that agreement will not form part of it, and that is when the parole evidence rule will properly apply. You can no longer bring into the picture any other conversations that were had to supplement, to contradict, or to vary the terms of that written agreement. Just in terms of our terminology, the word parole simply means extrinsic. So you can use those terms interchangeably, but the name of the rule for the purposes of your exam and any coursework is the parole evidence rule. So as we've discussed previously, it is possible to set aside the parole evidence rule, and that will only happen if one of the parties can prove that there was never an intention for the written contract to be the entire agreement. In other words, if one party can prove that there was an intention for the contract to be a mixed contract of oral terms and written terms. And the case that we have for that is J. Evans & Son and Andrea Mazzario. So in terms of this particular case and its facts, this was all about shipping of machinery from Italy to England. And in that particular circumstance, the shipper had the ability to ship the goods in whatever way they wanted to, either above deck or below deck. But prior to the goods being shipped from Italy to England, the shipper made an oral assurance to the owner of the machinery that they would be shipped below deck, much safer to do so. But in breach of that oral assurance, they shipped the goods above deck. It later turned out that the goods fell overboard and the owner of the machinery sued them for breach of contract, breach of that oral assurance that they would ship the goods in the safety of below deck. The defendant in that particular case turned around to say that the oral statement had no legal significance because there was a written contract there on their standard terms that didn't include the fact that they had to ship it below deck. They had complete freedom under their standard terms, but the court held in that particular circumstance that that contract was a mixed contract. It was on the basis of both their standard written terms, but they were overwritten by the oral assurance that they made, and the contract was mixed. There was no entire agreement clause that would have ousted any oral agreement, and ultimately, because it was a mixed contract, the courts were able to take that extrinsic evidence into account when informing the terms of that particular agreement. In our final slide then, we cover onerous terms. And the rule here is that when a clause is particularly onerous or unusual by relative industry standards, then the party that seeks to rely upon that clause must take reasonable steps to bring it to the attention of the other party. So if you are entering into a contract with someone and you want to include within that contract something which is strange or unusual, you must take reasonable steps to bring it to the other party's attention. And that was exactly what happened in the case of Interphoto and Stiletto programs, or what didn't happen in that particular case. So in this particular case, Stiletto wanted to rent effectively some stock images from Interphoto. And as part of Interphoto's terms and conditions, They had a term that if you failed to return the stock images within the prescribed time frame, that it would be a set amount of money per day. And that set amount of money was 10 times above the industry norm. It was an onerous term and it was unusual. And the point of this case was, because they did not point out that term to Stiletto, it was unenforceable. Because they did not take reasonable steps to bring it to the attention of Stiletto, it could not be relied upon. The reason I've got the red hand here is because this is effectively the same as the red hand rule that was expressed by Lord Denning in a rather famous case of Thornton and Shoe Lane parking. That particular case was all to do with the incorporation of an exemption clause, where Lord Denning set out that if you seek to rely upon an exemption clause, which again is an onerous term in its own right, then you must have a red hand pointing to it. It must be written in red ink, and that's what you must do to bring it to the reasonable attention of the other party. But this is all to do with onerous terms. We will discuss exemption clauses in a later video, but for now, just take away from this particular segment that if you've got an onerous term of a contract and you want to rely upon it, then you must take reasonable steps to bring it to the attention of the other party. What amounts to an onerous term is also something that you might want to consider, and that is ultimately down to a test of reasonableness. To the reasonable person observing the parties entering into that transaction, would that term be onerous, or would that reasonable person consider the term to be onerous? And that will take into account a variety of different factors. What is the industry norm, and so on. So there's a lot of things to think about if you're ever faced with an onerous provision within a contract law exam.